Hi everyone, this is Attorney Aaron from Indiana. I've got a new court case for you. Let's get started.
So last case will be Joseph Zamora, 23 CR 02260. And Mr. Zamora's case is a trespass alleged to have occurred on the 16th of March. This is alleged to have occurred at the Circus Circus. I have no objection to an OR release and just a stay away order from the Circus Circus, please.
Okay, Mr. Conway.
We'd echo in that request then.
Okay. I do note that it appears that Mr. Zamora has a hold for other matters, including matters in California. And I do note the alleged propensity to reoffend, and that he's repeatedly gone to the Circus Circus property.
No, I have not. No, I have not.
No, don't talk. Do not talk. Wow.
With that, I am going to allow him to be OR'd in this matter. I will impose a condition that he stay away from the entirety of the row during the pendency of this action, that being the property that comprised Circus Circus, Silver Legacy, and El Dorado. And I will tell you, sir, that you might have other matters that preclude you from being actually released today, but you are OR'd in this matter. Do you understand all that, sir?
They also damaged my hand. They damaged my hand and they damaged my right hand.
Okay, sir, that I hear you, and that's not a matter for this proceeding today.
Proceed on that, you know what I mean? But I'm just letting you know that I was handled very wrong. And also I noted that one of my girlfriend had lost the key there, and I called inside the casino before.
Sir, I'm going
to. The defense attorney is about to lose it, and I would be acting the same way. He should not. The client should not. Defendant should not be talking right now. The judge has just released him, OR'd him on this case. You got what you want. Stop talking. It's going to get worse from here. Hopefully he listens to his defense attorney right now and stops talking, but I don't know. Let's see.
Here, we've concluded the bail hearing, and as you heard me say, you got a right to remain silent, and that's probably your best course of action. Going to get you OR'd in this, and if you got other matters holding you up, that's beyond the reach of this court. That's court's order. Thank you, sir.
Sorry, the city does want to be.
Well, at least got him out of there for that one. So moving on to the next case here.
On release. My mouse is not working. And Your Honor, we would be asking for the court to impose bail on this case in the amount of $1,000 on each case. These are criminal trespass in the first degree matters. Each one of them, there are 3 charges. Mr. Swenson, when his release, fails to appear out of custody for court. In looking at his docket on the 5-8 matter, he has failed to appear on that case, I believe, twice. Well, one time mail was undeliverable, so he's failed to appear once on that matter, once on the 1623 matter, and then on the criminal trespass in the first degree that ends in 155. He was booked into jail, was given notice in jail, and then failed to appear for first out of custody court hearing. So the city has concerns of his ability to appear for an out of custody evaluation, and thus is requesting bail in the amount of $1,000 on each case.
Thank you. Does the defense want to respond?
Yes, Your Honor, we would request that he be released. Would apologize for missing court. Indicates to me that he is able to appear out of custody. The allegations in these reports, at least the most recent one, was that he was, I believe, charging his phone at a laundromat. I
was doing laundry.
We don't want to make any sort of admissions on the record, sir. Would ask that the court consider releasing him today, and I can fill in the dates depending on what Your Honor orders today.
Okay.
And Ms. Hickok, I just want to give you the opportunity. I know your client has wanted to talk numerous times. Do you need to speak to him or are we good?
I spoke with him at length before court today, Your Honor. Thank you.
Thank you. Based on the failures to appear, I'm concerned about him appearing for court. So I'm going to impose the $1,000 bail.
Good morning, Mr. Perkins.
Pretty straightforward. The judge had already decided once they had the failure to appear on the second defendant here, there's going to be a bail required for him to get out of jail. If he can post it, he'll be released. Otherwise, obviously, he's going to stay until the next hearing.
Your Honor, I'm adding another rights form, one that does not have him an X on it. So.
Oh, okay, that's fine. And you did review his rights at arraignment with him?
I did. Well, actually, since it's signed, I can't trash it anymore. I did review his rights. It has an X through it. That was before I got the notice, so it won't happen going forward. Okay.
That's okay, and he can sign the commitment form. Sir, is your true and correct name? Actually, let me read out the case numbers first. We have one matter in pretrial status, which is 2A0183861, and then one that is on for arraignment, 3A0302109. Is your true and correct name, sir, Larry Darnell Perkins?
Yes.
What is your date of birth?
7/12/1958.
Thank you. Mr. Gates, you may proceed.
Sir, you've been charged with the crime of driving under the influence of intoxicating liquor or any drug alleged to have occurred in Normandy Park, Washington on or about March 21st, 2023. Contrary to RCW 46.61.502, this is a gross misdemeanor punishable by up to 364 days in jail and a $5,000 fine with a mandatory minimum penalty given one prior qualifying conviction and a BAC of less than 0.15 of 30 days in jail and a $500 fine.
I'm sorry, I can't understand you, Mr. Perkins. What are you saying? Okay. All right. Mr. Poudre-Tudan, is your client pleading not guilty?
Yes, Your Honor, I'd like to waive formal reading of the complaint and enter a plea of not guilty. And I have gone over his rights as well, and he indicated he has no questions.
Okay. I'm sorry, I'm having issues with O Court. Give me just a moment here.
No worries, Your Honor. I was having issues as well earlier.
All right, so the court has reviewed the sworn statement of the citing officer in this case.
Initial hearing here in this case sounds like the defendant is upset about something on the charges. However, now is not the time to deal with anything that's alleged. It's just an initial hearing, so he'll have to work out any problems or concerns he has with his defense attorney, and those going to be addressed through a motion with the court or possibly directly with the prosecutor in an agreement. So,
probable cause to detain. Let me hear from the city on release and any relevant prior criminal history.
Your Honor, Mr. Perkins was just arraigned on that other case about 2 weeks ago after warrants twice had already issued for his failures to appear. At arraignment, he was instructed to have no new criminal law violations. Obviously, the new allegation would constitute.
I wouldn't have any criminal law violation if you had just left me alone.
All right, Mr. Perkins, these are just allegations at this point. There's only probable cause to believe a crime was committed, not proof beyond a reasonable doubt. So,
moreover,
we don't talk over each other, Mr. Perkins. Yeah. I'll allow you to say something if you wish, although I think your attorney would probably advise otherwise, since anything you say can be used against you. But I'll give you the opportunity to speak, I promise. Go ahead, Mr. Gates.
Thank you, Your Honor. Moreover, although Mr. Perkins has no out-of-state DUI-related history that the city can find, he does have a DUI conviction out of King County District Court from August of 2016, which is within 7 years. Given his, shall we say, quick turnaround on allegedly violating his pretrial release conditions in his other case, as well as the prior DUI conviction, Your Honor, the city recommends he be held on $25,000 bail, that he be ordered to undergo random UAs, as this is a allegedly drug-related DUI. And the city further requests that the court revoke his PR in the other case and impose bail in an amount deemed appropriate. Thank you.
Wow, $25,000 for an OWI. I get it. The state's alleging that it's the second OWI within 2 weeks. However, these are allegations, not convictions. Seems pretty steep to me. Let's see what judge does here.
Right, Mr. Pujura Tudan, I will hear from you.
Yes, Your Honor. I'd be asking for my client's release on personal recognizance. He has several health issues and he's prescribed medications. He indicated to me that he has diabetes as well as a heart condition. He has issues seeing as well as issues walking. He explained to me that he has no ability to post bail. He has no one who could bail him out. He has no job. His car was impounded and it's something that he cannot afford. So imposing bail would create further financial struggle. He has no housing, but he works with caseworkers at the VA for services, and that's where he gets most of his resources. And based off the facts alleged in the police report, I do not believe he's a danger to society. And I'd be asking for him to for a chance to appear at out of custody. Thank you, Your Honor.
Your Honor, the city forgot to add one final thing. Given his prior qualifying conviction, either SCRAM or IID would presumptively be a requirement. Again, as this is a drug-related DUI, the city would defer to the court as to which of the alternatives to impose. Thank you.
And on that note, Your Honor, aside from bail, I don't object to the conditions of release. However, if he is imposed with other SCRAM and IID, I'd ask if the court could possibly foot the costs, or the reason being is he has no ability to pay for it whatsoever. Thank you.
Okay, starting first with the arraignment case. A condition, when I impose as a condition of release, not to commit any new criminal law violations, the court, in terms of violating conditions of release, and the court at least has probable cause to believe that a new offense was committed, that is one of the most serious violations of a condition of release that the court can think of. So for that reason, I am going to revoke the PR in the other matter and set bail at $1,000. And on the DUI case, actually, I'm sorry, on the, so on case 861, bail will be set in the amount of $1,000. On case ending 109, the DUI case, based on his warrant history, I have no confidence that he is going to reappear. I gave him, an opportunity on the other case, and now he's picked up a new charge. So I'm going to set bail on the DUI in the amount of $5,000. I will order random UAs and SCRAM, court pay SCRAM. Additional conditions, if he were to post, are that you're to have no criminal law violations, appear on time to any scheduled court hearings. You must not refuse a breath or blood test when lawfully requested by law enforcement. You must not use or possess any alcohol, non-prescribed drugs, marijuana, or drug paraphernalia. Keep the court updated with any address changes. And you will be required to have the SCRAM device installed. That will be at no cost to you within 48 hours of your release. We will also provide you with instructions on the random drug testing. And we can set this, well, both of these matters we will set for Monday, the 27th.
Well, the most interesting thing I heard was no unprescribed marijuana. So obviously marijuana can be prescribed in Washington State. Even though it's legal, you can't have it if you're on release from court, it sounds like. Regardless, this defendant is not going to be able to be released. His defense attorney has stated that he has no available funds for posting bond. So whether it's $100 or 500 or 1,000 or 5,000, it's not gonna work for him. So he's gonna be staying in jail until his next hearing. So unfortunately, he's not going anywhere.
And you will be able to contact your attorney while in custody. If you were to bail out, then you are to appear in person for that Monday court date.
I can't go out tonight. I ain't got no money. Until the 27th.
All right. Was there anything else that you wanted to say or any questions you had about any of the conditions?
Yeah, I wasn't doing no drugs, I was drinking.
Okay, well, you don't want to talk about the facts,
Well,
of the
yeah.
case, sir. That would work against your self-interest.
Yeah, let's not talk about any of the facts, sir.
The best thing you can do is contact your public defender from the jail, have a further consultation about both of these cases, and I'm sure that your attorney will be in touch with the prosecutor regarding, how the case is likely to proceed or any plea negotiations, anything like that. And then we'll set this for Monday and see where we go from there, okay? So I've signed the order. You can go ahead and step out.
I didn't talk to my attorney. No,
Well, do you want to spend just a couple minutes talking to him now since he's the last one, and then, but really no more than 5 minutes. If you want to schedule a time for another I'm sorry?
I have to talk to him right now if I can.
Okay, you can talk to him for 5 minutes, but then after that, Andrew, we're going to need the other individuals to come in who need to talk to Triana.
Well, obviously he's going to be staying in jail. I'm glad he's getting to talk to his attorney now. Hopefully the attorney can work out something with the prosecutor and get these cases resolved quickly and get this man back out of jail. Doesn't sound like maybe if he's having sight problems, he probably shouldn't be driving. Regardless, hopefully his medications can maybe correct those things, and he can still be safe for society. Might have a suspended license for a period of time, but surely, or I hope he doesn't have any executed time incarcerated for these charges. We'll see. All right. See you next time. Thanks.